Today's hearing will investigate the current landscape around antitrust liability for the NCAA, which has created issues around name, image, and likeness payments, known as NIL, the transfer portal, and eligibility rules in college athletics. A series of court opinions finding antitrust liability against the NCAA, most notably the Supreme Court's 2021 Alston decision, calls into question the legality of any rules that limit compensation for student athletes. Further, a patchwork of state laws has made it difficult, if not impossible, for the NCAA to regulate NIL payments to student athletes. An additional ongoing litigation strongly suggests rules governing student athletes transferring schools and eligibility requirements will also be found to violate the antitrust laws. College sports is rapidly heading in the direction of unlimited payments, unlimited transfers, and no rules around who is eligible to compete. In October of 2024, the U.S. District Court for the Northern District of California granted preliminary approval of a settlement agreement in House versus the NCAA, known as the House Settlement. That paves the way for the first revenue-sharing model in college athletics. It also creates a framework to govern NIL payments from so-called quote-unquote boosters, also known as collectives, and replaces scholarship caps with roster caps. The House settlement does not resolve other pending antitrust litigation against the NCAA, nor does it immunize it from many subsequent antitrust challenges. Further, the House settlement is the product of the NCAA conferences and the plaintiffs' lawyers. Schools, coaches, and athletes largely did not have a seat at that table. Under the current framework, any rule that the NCAA attempts to enforce will face immediate litigation, and history suggests that the NCAA will likely lose every time. Most people can agree that the NCAA went too far with their regulations in the past. For example, the NCAA placed rules around the exact type of snacks student athletes could receive from their teams, prohibited transfers without penalty, and barred legitimate third-party NIL payments. The NCAA was too late to acknowledge that some college sports are large commercial enterprises, and certain student athletes bring great value to their schools. But now, college sports has largely lost any resemblance of the amateur sports that they used to be or collegiate spirit, even when the cost of a sport consistently and greatly exceeds any revenue from it. College sports are rife with play for pay schemes from boosters and schools. And the educational mission of college athletics has been eroded. Specifically, multiple transfers hinder pathways to graduation, and a lack of eligibility rules encourage individuals to stay in college long beyond the average four-year period. Coaches are finding it difficult to manage their teams because students can transfer at a drop of a hat. This scenario leaves coaches without a functioning roster and harms the student athletes that value consistency in educational and sports programs. Colleges must also shift their recruiting strategies. Recruiting high school athletes is not the focus for some coaches anymore, because getting athletes from the transfer portal is more cost-effective than training the next generation of athletes from the group up. The inability of the NCAA to set rules has turned college and athletics into what would be called by some a semi-professional endeavor, focused more and more on men's football and basketball. The witnesses we have today are perfectly prepared to supply members of the committee with the required information to better inform us as we work on possible solutions to help ensure that college athletics programs remain accessible for the next generation of student athletes. I want to thank the witnesses for appearing before us today and look forward to hearing what each of you has to say.